The home care benefits.
Jacob just wanted to say that the home care benefits, I mean, that's what we get the most out of from the Medicaid waiver is coverage for personal care attendants or CNAs at our house. And so he gets, I don't know, 50, 60 hours a week covered plus overnights.
Oh, you get overnights too. So some of these programs offer a budget to work with to hire, like you said, personal care attendants so that they can help out during the day or night. So that's a huge plus.
I wish I'd heard about that HPP thing when I was working because, you know, they took money out of my paycheck every month for the insurance. I didn't know that they covered that.
They do in Texas if you qualify. So if you know, some of our kids like on the spectrum, maybe they're past ABA therapy, and so they're not really going and using your insurance. Then the state of Texas is not going to cover your premium if you don't really use the health insurance. But you know, for our kids on the with DMD, you have significant medical costs. And so, yes, you might qualify for the Get Hip program. I had a question.
Run into the doctor all the time. That would have been helpful.
Yeah. DJ has a question. What are the differences between intellectual developmental waiver and the aged and disabled waiver? So I'm not familiar with those names of waivers. Is that for Texas? But what we do have is IDD, intellectual and developmental disability. Let's see. West Virginia. Okay. I don't know the difference between those waivers. We have, so what we have, it used to be called Department of Aging and Disability. That was DADS. That was the government body that oversaw the administration of certain waivers. Now that's been taken over by Health and Human Services Commission at the state level. And then we would have other waiver programs administered at the local level. In Harris County, Texas, where I'm at, we used to have something called MHMRA, which was Mental Health, Mental Retardation Administration, I believe. And so now it's been rebranded to the Harris Center. So that might be what you're talking about, administration at state level and administration at local level. Seema said, what if parents are divorced? My understanding for the Get Hip program is that if you cover someone in your household that receives Medicaid benefits, then you would qualify for reimbursement on employer provided insurance, if that was what you were asking about.
I'm going to jump in real quick. I'm back. I was having a little bit of technical difficulties. So yes, and for the divorce, Seamus, we're going to be talking about that in just a couple minutes with the special needs trusts, the SNTs. But before we go on any further, right before my computer booted me off, could we drive home again real quick the reason why these understanding kind of the legal rights and the legal steps are important? Tell us a little bit about the eligibility. Again, what has to happen for an individual to be even eligible to receive these things?
So typically, when you, and this is what happened to me, when you think of Medicaid, you think of, well, you have to have little to no income and little to no assets. And then what I think what I'm familiar with is there's a formula for how much you can make in your income. And then you can have $2,000 or less in the value of your assets to qualify for Medicaid. And so a lot of our families, they have assets. They may have somebody that works full time, so they won't qualify for traditional Medicaid. So then what happens is you have to wait until your child turns 18. And then they can qualify on their own for traditional Medicaid and SSI if their disability makes it where they cannot work. Instead of waiting until your child's 18, they can possibly come off of these interest lists before then so that you can get them some of the Medicaid waiver services. And then with the services, comes the ability to apply for the Get Hip program. So you're benefiting your child with therapies, with home mods, and Lindy said with some prescriptions covered. And so respite, personal attendance, you can have all these things, but at no cost. It is free. It's provided by the government, but you have to wait for so many years to actually get off of the interest list. Then you would be go through the interview process, and then hopefully you would be qualified.
Very good. Let's see. Somebody asked, is there a HIP program for each state?
I don't know. I don't know. I'm sorry.
Okay. Leona's licensed in North Dakota and Texas. So some of this information you'll need to get details about in your own state. See an attorney.
Contact Health and Human Services Commission. So type in your state and then HHS. And then you should be able to navigate that, or at least contact one of their agents.
So let's jump into number 2, unless y'all already covered it while I was frantically trying to reconnect. The IQ, why would we, whoa. Again, technical difficulties.
So for IQ, what I discovered, at least in Texas, is that at least one of the programs is based on eligibility, includes IQ level, and it needs to be at either 70 or 75. Well, what happens is with DMD, typically you don't think of having IQ issues or intellectual disability, but one of the previous YouTubes that I've seen that Lindy has hosted was with Dr. Natalie Truba, and she discussed comorbidity being pretty high, the rate of comorbidity being pretty high with kids that have DMD. And so with Duchenne, there may be a second diagnosis. And if there is an issue with capacity, then go ahead and get it's called a DID, Determination of Intellectual Disability. And to be eligible for some programs that eligibility is based on IQ, you would have to have the IQ tested at a authorized place, which would be the local authority. So again, in Harris County, you would contact the Harris Center. So contact Health and Human Services and see where they would like you to go for a free determination of intellectual disability for your child.
And this is so important, because with Duchenne, we've got such a varying amount of intellectual challenges. And just because your kid might have some ADHD or problems focusing or can't learn math so well, it doesn't necessarily mean they've got a low IQ. My kiddo has all of those things, and he's actually a little bit higher than normal. IQ doesn't matter that much to me, but just for an example, you can't tell just by interacting if your child's going to qualify or not. So it's a really great idea to go get that test done. Okay, so let's jump into the next one. So for Leona, at least in Texas, the assets for the individual to be approved is limited at $2,000. So tell us, how in the world are we going to get our child when we've got people who give them gifts, and we've got vans, and we've got well-meaning grandparents? How are we going to keep our child's assets at $2,000 or less legally?
Legally. Okay, I like one ability, one thing that you would use is something called a supplemental needs trust. Now there's multiple types of supplemental needs trust. We have first party, and then we have third party. We also, if your state has a nonprofit that may run something called a pooled trust, but you would go to an attorney and you would ask for the drafting of a third party supplemental needs trust. What it is it's an agreement that let's say it's two parents and one child with D&D. So the parents would be the initial grantors, putting down $100 or something towards the consideration for that agreement. Then what you have is parents as the initial trustees. So for parents that are going to fund that trust before they die, they would be in charge of distributing the assets or managing the assets. When I'm drafting special needs trust or supplemental needs trust, I ask for at least a couple of sets of successor trustees, because I want to make sure that this trust, you have decided who would be in charge of this trust, so that it will cover your child's benefits, or it would protect your child's benefits for the rest of your child's life. And that is important for third-party supplemental needs trust. It's its own separate entity. It has its own tax ID number. And what you would do is you would list the supplemental needs trust in your wills. You would list instead of your child, because your child is not supposed to own any assets or anything over $2,000. You would want the trust to be what you designate as a beneficiary in your life insurance policies. Because if your child inherits from you or gets life insurance, a payout, cash is an asset. And so if they inherit more than $2,000, then they will be kicked off of they can be kicked off of their program, their waiver program or Medicaid. So the way that you protect them now and in the future is with these special needs trusts. Now, that's a third-party trust. We also have a self-settled trust or a first-party supplemental needs trust. And the type of funds that you would use, that you would put into that trust, are either settlements from a personal injury lawsuit, or what's more likely, it's for used in a divorce. So in Texas, we have something called indefinite child support. If you have a child with special needs who will require substantial care, you can have the obligor parent pay child support for the rest of that child's life. And so that is it would be paid into the first party trust, not to the other parent directly or through Office of the Attorney General. It would be paid to that parent as trustee of that first party trust. And so a lot of parents didn't know this, and this is kind of why we focused Phyllis Law Firm focused it to help families with children with special needs, because there's lots of wonderful family law attorneys out there, but they may not know about the ramifications of how child support affects the child's eligibility for benefits. The problem is Social Security Administration, who administers SSI and Medicaid, they deem child support as unearned income against the child. So you may have done the right thing by asking your attorney to get indefinite child support for your child, but then they didn't put it payable to a trust. And so then Social Security, once your child comes off of the interest list for the Medicaid waiver programs, or once they qualify on their own for SSI and Medicaid after they turn 18, they're going to have the child support counted against them. And if it's in a significant amount of child support, then it's going to disqualify that child from getting SSI and Medicaid. So it's as simple as getting the trust.
Whenever you and I first stumbled upon that, I was just floored. I was like, what? From child support, and clearly it's supposed to go to support the child, but putting it in this in the child's name and having them excluded from eligibility, it was just, it astonished me. It astonished me. I do have to say, guys, it's not as painful as it sounds. When I was going through the SNT with Leona, setting up the third party for us, it was what, 10 pages of questions and thinking, and it took maybe a couple weeks. But I feel a lot better. I finally did this at the beginning of COVID when I wasn't sure what our future was like. But Leona's been on me about this since we were on the waiting list. So what happens if you don't have an SNT and you're on the waiting list and your child suddenly has over $2,000 in assets?
So then they won't qualify. So one of the things about the Medicaid waiver programs is they waive looking at household income and household assets, and they just focus on the disabled applicant's household income and assets. And so if they have inherited one half of the house or received money paid to them because you listed them on your life insurance, or if you didn't have a will to begin with. And so by the state's intestacy laws, it depends on your state, but in Texas, if you're not married but you have children and you die without a will, you're dying intestate. And so the default rules apply, which means your kids instantly inherit everything that you have, which will be most likely valued over $2,000. So then, now that they're dealing with your death, they're also having to deal with getting back on Medicaid and SSI and getting their benefits back. So everything halts. Everything, all their therapies, the respite care, the personal care, all that stops if they've been receiving that through the Medicaid waiver program or through Medicaid, and then they inherit. So it's a simple fix.
Yeah, and sorry, go ahead.
Seamus has a hand raised.
Yes, and I wanted to, can I do this? I don't know if I can do this. There you go, please.
Okay, so Kelly and I are both on this call. We're divorced parents of 3 kids with Duchenne. And then when you were talking about third-party trust, is it a better idea to have 3 different third-party trusts for our boys since they all have Duchenne, or one third-party trust to include all 3 of them? Because they all 3 have Duchenne. So that's kind of where I'm like, I don't know where to go with this.
So in Texas, you have to have, you only have one trust per person. So you would have to get 3 separate trusts. Now you can, in the trust agreement, determine who would be the future beneficiaries in the event that your child passes. And then if the trust was funded, you can determine where those funds go. But you will have to have 3 individual trusts for estate planning purposes and for their protection.
Thank you.
And so, and Kelly asked a question: do we need separate trusts or combined by us? 2 estates times 3.
Okay, so so this is one thing that I've seen attorneys do, and I really am very much against it. I have seen people who will pay for a will, and in the will it says, if my grandson Charlie, who has DMD, survives me, then I want his interest to go into a trust that's created at that time, a third-party trust. Well, everybody's waiting around. There's no trust, so no one can utilize that trust, and it's only contingent upon certain things happening that it ever even gets drafted. What I suggest is that you have one trust per person, and so per individual, and everybody points to that trust. Everybody meaning mom, dad, grandparents, friends, family. Once, Lindy, I told you, once we get the trust agreement signed and executed, and we have that taxpayer ID number, you get to draft this wonderful message and share it with all the family and friends and say, hey, if you want to leave anything to my son, now you not mess with his benefits. Please go forward. We have a bank account over at Chase or Wells Fargo, and they can freely pay into this trust. So have one trust per child.
And, we'll get to that in a little bit, but that is an important part. Whenever we got the trust set up, my mom altered a little bit of language in her will. So she didn't want to posthumously kick her son out of getting medical care. So that was great. Let me see. Okay. And then the kicker, Leona, about how much does it cost for an SNT?
Okay. So I've kind of, looked around with other attorneys too, not just myself, but the average price is about $2,500. Now that should include the supplemental needs trust agreement, the certification of trust, which is basically an abbreviated form of the trust that you would utilize if the trust is going to own and sell real property. You don't need to have the entire trust put into the real property records. You would just have the certification of trust, because the trust can own the transportation vehicles. It can own interest in businesses. It can own your house, or it can own anything, because it is an entity of its in and of itself. And so yes, $2,500. You should expect something around that amount.
And this just kind of clicked in my head earlier. You've got, as a parent of a child with DMD, you've got your physical child who you love and care for and hug and all of that great stuff. And then you've got your financial child, which is your SNT. So if that makes sense, it makes sense in my brain. I don't know if it makes sense to anybody else. I did have another question with this. Oh, yes. So the trust is specific to the child, correct, Leona? So if you're divorced, you don't need a trust for each parent and the child. It's just the kiddo. So if you've got 2 kids and you're divorced, then it's 2,500-ish times 2, right?
And I would say this, try to work together so that you can be co-independent trustees. Even if you're divorced, you're probably still co-parenting. And so that's allowed. You don't have to just have first mom, then dad. You can have both of them, even if they're divorced, as co-trustees. Then, pick parents or cousins or aunts or uncles or family members or friends that are trustworthy, that would be on your key people list of who you trust to help take care of your child financially. That's who should be in your list of successor trustees. Does it have to go to Social Security? No. So Social Security will ask, what assets do you have? And they will want to know what is in your child's name. Well, this is a separate entity. So this is why we do it. You can shield everything that you want your child to have in the future by putting it or naming it to be the trust as the recipient, not your child. So you can tell Social Security that you have a trust, but it's none of their business of what's in your trust, first party trust, with a third party trust. That's the one you use in your wills. That's the one you use for estate planning. A first party trust, which you use with child support, that one, there is something called Medicaid Estate Recovery Program, MERP. And so this, along with the 529A bank accounts that we'll talk about in a little bit, there's the funds that are in the first party supplemental needs trust or the funds that are in a 529A savings account are subject to MERP. So Medicaid, through Social Security Administration, has the right, when the account holder, the disabled person, dies, that estate is subject to Medicaid going in and getting reimbursed for the money that Medicaid has paid out over the lifetime of the disabled person. They can, if they've put out, what did you say, Lindy, $1 million worth of
Yeah.
so don't keep $1 million in your account. Let's just say that Medicaid has paid $300,000 worth of bills on behalf of your child. Well, Medicaid would have the right to try to recover and get reimbursed for that amount out of a first party trust and a savings, the 529A savings account. But your first party trust, most likely you're going to use that for child support. You're probably going to be pulling out that amount to pay for allowable expenses every month. Don't use that as a savings account. Use a third party trust bank account as a savings account, not a first party.
I just want to jump in real quick and let everybody know. So we finally set up the S&T for my son. And when my son was approved for the Medicaid waiver program, and whenever we had to reapply, because they kind of check in on you, and does your kid still need it? Yes, he has Duchenne, he still needs it. They asked about the assets this time. And so I did have to submit the documents, like the whole shebang. Leona said, well, you can just, do this little short thing. And yeah, no, they were not happy with that. They wanted the whole 18-page thing. So Medicaid will ask you for that. And this is following up on Jacob's question. Medicaid will ask you for that. So be sure to have it handy.
But you don't file the trust
Right.
like in the real property records or with something in your county or your state. For owning real property, the ability for the trustees to sell property in the name of the trust, you'd have to prove their authority to do it. And so that's when you use the certification of trust along with the deed to show that the person signing off as trustee actually has that authority. So yeah, it's a little tricky.
Yeah, DJ. They don't make it easy. It was funny. I was chatting with somebody, DJ, you were on the call actually, I think, somebody in England, and she was like, yeah, if we had to deal with all of the stuff that you guys in the States have to deal with legal stuff and insurance, she's like, I wouldn't be able to do it and manage Duchenne at the same time. It's a lot. It's a lot. Okay, cool. I think we're pretty good there. How about we jump on to, and I haven't done this one yet, Leona. Step 4, life and disability insurance for parents. My husband has it. Should I be telling the world this? But something we need to do for me.
Wendy's slacking. Okay. So, some of our families will have a caregiver parent and a breadwinner parent. And usually parents will have life insurance and maybe even disability insurance on the breadwinner parent because it's something that comes with their employment benefits. But you do need to have life insurance and disability insurance on the caregiver parent. If something happens to him or her, they could become disabled. They most likely have to be replaced by a team of people. So Lindy can probably go through and tell you 12 things that she does for her son before 10 a.m. And she does it with love, and she does it to the best of her ability, which is awesome. But if something were to happen to Lindy, it would probably, my brother would have to probably hire a team of people to make sure that all of my nephew's needs are being met. It's never going to be as good as if Lindy was doing it, but it still needs to get done. And so you need to have the funds ready in place to pay for this if there's disability or death. So that is something that you parents can do on your own. You don't need an attorney to get the insurance for you, but this is something that if you haven't done, you should.
Yeah, and this really hit home for me when last year I was having some crazy stomach stuff and I had to go to the ER several times, and I was like, oh yeah, this is why, Leona. This is why I'm supposed to have health insurance, because like you told me when we were talking about this for the first time years ago, if your husband is grieving, if your kids are grieving, you just want somebody to be able to step in right away and get your son stretched still, get him his meds. Take care of your kids who don't have DMD. You don't want to be messing with trying to find the money to pay for the team who's going to come in to replace everybody. It's too much. It's too much, and it's not fair to the kids.
There's something that I'm starting to explore, making a template or something for. It's called a letter of intent for my child's future caregiver. And that's something that you can probably look online and find something to guide you. But basically, it's a booklet about your child. What are their likes, their dislikes? Who are their doctors currently? What your goals are for your child in the next 3 years, the next 5 years. It's basically just a handbook that you can give to someone to pick up where you have left off. And so that is another thing that you can do on your own. Get a letter of intent kind of written. Pretty nice.
And this is great. I believe it's the Jet Foundation did something like this. They had a webinar, but they call it the Book of Knowledge.
Okay.
And so it's specific to DMD families, and it's like this thing where you fill it out, and it's several inches, and yeah, it's a thing. But like DJ said, you've got to dump it all out somewhere, because yes, there's preferences, and you would like your child to still be comfortable, but there's like medical stuff that if it's overlooked, it could be life-threatening for sure. Okay, let's jump into, and I guess for the how much, Leona, that just varies dramatically according to where you want to invest and blah 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 blah, right? For life insurance, disability insurance.
Disability insurance, I would,
Just
contact, I don't know if y'all are on other Facebook groups for parents with kids with special needs, or parents with kids with DMD, but usually if you throw something in a chat like that, you might have someone who can point you to a broker or an agent.
fantastic. Okay, so let's jump into the ABLE accounts. I'm still kind of fuzzy on this. I might need another 2 or 3 years of you talking to me about it to really get it. So the ABLE, or the 529A savings account, what is it?
So a few years ago, legislation was approved at the federal level, and now it is available at the state level. It is the ability to save money for a person with a disability without that savings applying against them as an asset, so that they would be disqualified for Medicaid. So there was an example of someone who had worked part-time, and he was saving up to buy a car, but he was also receiving government benefits, and he could never save enough for a car because that cash would exceed the $2,000 maximum asset level. And so there was this disconnect with, when you're talking about, reality, how do you save money but also keep your benefits? And so the ABLE account, ABLE is an acronym for Achieving a Better Life Existence. And so what it is that every state, you can contact whatever bank you use and ask them if they have 529A savings accounts. 529, a lot of people know these accounts. Those are the type of savings accounts for college. You can put money aside for your child for college, and the interest earned is not taxable. So what we have for people with disabilities with the 529A is that you can deposit money in there. Now there are maximum restrictions. You can only deposit, I think they just increased it to $16,000 a year. But usually the amount that can be deposited in the account and still be protected, shielded from Social Security looking at it as an asset, it usually is tied to the annual gift tax exclusion. So for right now in 2022, you can deposit $16,000 into your child's ABLE account. and then let it grow, let it sit there and grow, and the interest earned is not taxable. As long as you're spending the money when you do pull it out on what they deem as allowable expenses. And we dropped in the chat a link to ABLE accounts for Texas. Every state, again, has their own legislation, so they may have different rules, but this is an excellent way to save money for your child for summer camp. Doctor bills that are not covered by insurance or Medicaid. There's all types of different expenses that you can spend ABLE money on. Now, you can't, this is not a device that you would use in your estate planning. You're not going to leave money to a bank account. You would leave money to the trust, which is a separate entity. So some people are like, well, what's the difference between 529A bank accounts and third-party supplemental needs trust? So again, they're both ways where you can save money, and it's shielded from Social Security looking at it as an asset and disqualifying your child from government benefits. But the special needs trust is its own entity, own taxpayer ID number, and that can hold money. It can hold interest in ownership interest in houses, real estate, cars, trucks, vans, those special customized vans that you might need. That can be owned by the trust. The bank account is a bank account.
So who owns the bank account? The individual with the disability or the SNT?
No, the individual and the it's not called a rep payee, but it's something along those lines. Rep payee is what you use for SSI bank accounts. But there's an individual who is authorized to make payments on your behalf out from the funds that are within the 529A savings account. So the trust owns whatever it wants, but the 529A bank account has to be tied to the person with a disability.
Okay, and does that, but the government doesn't consider it as an asset when examining eligibility for a Medicaid waiver program, is that correct?
That is correct. But
Okay.
one of the downfalls of, okay, so for Texas and 529A bank accounts, the first 100,000 is shielded from Social Security looking at it as an asset.
Okay.
So if you want to put your child's Christmas gifts and birthday gifts, if they get cash from relatives and you want to teach them a little bit about savings and investing, you'd put it in a 529A bank account. That's fine. But remember, MERP, Medicaid Estate Recovery Program, will have access to that bank account when your child passes away.
Oh gosh, so many things to learn. I thought I'd done with school when I learned all of the medical stuff with Duchenne. Now I'm learning my legal stuff with you, Leona. Okay, so just one more question for clarification, mainly for me, not for you guys, mainly for me. So is this an example of where an individual with a disability can actually manage his or her own money? Because like with the SNT, they can't touch it. Somebody else has to do all the work for them. But are they able to actually be an adult and manage their own money?
So that was the purpose of the person with a disability that was trying to save money for a car. Now things will vary from state to state. They each have their own rules, right? So I would look up ABLE account for your state to see exactly what is necessary. If you have to have a second person on the account with you to co-manage with you, if there may be an age thing, because you can sign up your minor child to have this 529A savings account. You can have money set aside for their college, but there's also all these other benefit expenses that are allowed to have the money spent for your child. So I would look to the state to see exactly what their requirements are.
Okay, fantastic. So it's an avenue where they can actually manage their own money, enjoy one of the enjoy money management, one of the things that go along with adult life. However, when they pass away, the money is eligible to go back to the state. So there's still a game that you have to kind of play in there. Yeah. Okay.
Just be aware of that. Like in Texas, you can deposit over time because there's those contribution restrictions, $16,000 a year. But let's say over time you've amassed close to 100,000 in that bank account. Be careful. Start putting money into the third party trust, because if you exceed 100,000, then even though you can put as much as 300,000, if you exceed 100,000, anything over 100,000 will be counted as an asset by Social Security. And so you've now lost the whole benefit of having an ABLE account because you've gone over the shielded amount threshold. And so if you have, and start diversifying, do something else. Third party supplemental needs trust. And then you don't want to keep it in there. I would say put the money in there to let it grow tax free, and then start moving it in chunks to the third party trust.
Here's another great tip. Make sure somehow that you have a special needs attorney in your family somehow, so you can call and bug them at any time. Because I think I'm the luckiest person in the world to have a special needs attorney as my sister-in-law, and I have a child with Duchenne muscular dystrophy. Yeah, it's so much. It's so much. And really not a plug for you, but how do people really know all of these details? How do you know if your own attorney knows what they need to know?
And that's part of that. No, that's a frequent problem that I've seen, especially when I don't handle contested cases. I have too much on my plate to deal with, fighting back and forth. So when I do help out with family law cases, it's usually to help fix problems that were missed. And they may have had an excellent family law attorney, but the family law attorney didn't understand the child support would be counted against the child and disqualify them from SSI. And then you need to ask for first party trust. And, you don't know what your attorney doesn't know. And it took years, like I said, to research and figure out what are the ways to navigate the legal system to help families with special needs that have kids with special needs.
And this just occurred to me, but in the Duchenne community, as you know, there are times we come across doctors where we really have to advocate, and we have to know more than the doctors. And it just occurred to me, you've got to know more than your attorney does, maybe. And I've had that luxury of having you in my life telling me what to do for years and years and years. But man, wow, that's another layer to Duchenne that I hadn't thought about. So that legal degree is kind of put that on your to-do list, parents. Go ahead and high school legal degrees. Good times. Okay, I'm a little brain dead from that. Let's skip over to step 6. This is an easy one. Updating the adult will in your family.
Okay. Step 6 is which one?
Updating the adult wills. So like we got the SNT set up, and I told my mom I need to tell anybody else who might want to leave my son, I don't know, $500,000.
Yes, immediately get on it. So this is one of the ways that we have to follow through with the next step. So the first step is getting your child on the Medicaid waiver program interest list so that they can start getting benefits earlier than 18 years old, when they can qualify on their own for traditional Medicaid and SSI. But we also need to then protect that eligibility with the supplemental needs trust, third party supplemental needs trust. So then if you don't have a will, then as we talked about a little bit earlier, the laws of intestacy will then apply when you pass away, and your child may inherit from you. And if they inherit something from you that's valued at more than $2,000, you have now jeopardized their benefits. Let's say you do have a will, but you have the standard will, we do wills all the time. I leave everything to my spouse. If my spouse predeceases me, I leave everything to be divided equally among my children. So yes, I don't want you to not give your son money. I don't want you to leave him out of your will. But what you do is you take that opportunity to point to that supplemental needs trust. So in the event that you have children that you want to provide for in your will, and one of your children has special needs, that child's interest should be allocated to be paid to their third-party trust. So that way, whenever you pass and the will is going through probate, that trust will be what is funded. And so that's what your executor would handle. You would use, again, that third-party trust for your life insurance policy. So when you get to designate beneficiaries, initially you may designate your spouse, but then you have an option for alternate beneficiaries. If your spouse has predeceased you, you want your children listed, but you don't want your child with disabilities listed, because if they receive that inheritance or that life insurance, the proceeds, that is an asset, and then that asset, if it exceeds $2,000, would disqualify your child from government benefits.
Yeah, and I hate to think about this. Part of my brain says, oh, you know what, if he goes before me, I'll just update everything. Well, the reality is sometimes parents go at the same time.
Yeah.
And you don't have time to update everything after the fact. You got to do it while y'all are both alive, and can avoid that sort of situation. Let's see. Oh, that's a great question, Jacob. What happens to the money in the S&T when the kid dies? That's something we can give you a teaser, but Leona and I decided to save that for the adult with DMD legal question. How about can we tackle that at the end, Jacob? Tackle that at the end after we get through a little bit more. Okay, so the wills, and be sure you talk to the grandparents. Be sure you talk to any well-meaning neighbor. Tell them, hey guys, look, S&T, please take my son's name out of everything. Let's see. Oh, how much, Leona? How much does that kind of thing cost?
Oh, okay. So rough estimate in Houston, Texas, estate planning for a couple, just the wills themselves, because you've already had the trust created, or you can have the trust drafted at the same time as your wills. So the trust is around $2,500. Same thing with the estate planning for a couple, but that's if you're going to also include power of attorney, medical power of attorney, physician's directive, guardian, designation of guardian of my children in the event of my incapacity or death, designation of guardian for myself upon incapacity. These are other documents that HIPAA release. These are all documents that you can have prepared alongside with your wills. And so that cost for a couple is probably going to run you around $2,500. Okay.
So, and I remember working these numbers with you way back when. So even though the families might have to pay up to $5,000 to get their child eligible for Medicaid, in the long run, if they're like literally saving $1 million because the Medicaid program is paying for their child's medical bills, that's a nice trade-off. It seems kind of unbelievable, but it can happen, and I'm already seeing that. My son's only 11, and I know the expenses increase as the individual with Duchenne gets older. So yeah, $5,000 can be tough to swallow, but it's really important.
So when I
in my opinion,
when I talk to people about benefits, and we talk about SSI, and it's right now it's $841 a month. It's not just the SSI, it's also the Medicaid that goes with it. And so that's very significant for families that have medical expenses that can run up to $1 million.
And I'll plop that link in there again where we're getting that $1 million number from. Okay, I think we're good there. Could we tackle step 7 special ed /504 briefly?
Okay. So if you're going to choose to have your child go to public school instead of a private school or instead of homeschool, there are certain protections in place at a federal level for public schools for your students. And so one of the things that you would want to discuss with your diagnostician or the principal, you'd want to make sure that your child is assessed to see if they're eligible for special education services. Do they need accommodations in place to help them in a educational setting? With kids with Duchenne, sometimes you might get by with something called Section 504. And what that is to protect a person with disability, protect their rights to have just about like equal access to different environments and to receiving services at school. So some of the kids with Duchenne may need extra time with tests. They may need to leave the classroom early so they can navigate the hallway without it being crowded. And then they may need, depending on their ability for writing, they may need a scribe or to have the right to record the school session. You may want to have included in the either special ed, it's called individualized education plan, so it's an IEP. You may have an IEP or a Section 504 agreement with the school about having your child receive physical therapy or occupational therapy. Some of our kids need speech therapy there on site. Now you have to remember, the therapies are limited to what will help the child in an educational setting. So you're still going to have to, do the stretching and the physical therapy at home. Don't rely on the school to provide the necessary therapy to meet all of your child's needs. It's just to meet their needs in an educational setting. With my son, Jonathan, we had speech therapy. And my mom typically would be the one taking him across town to the speech therapist for a 45-minute session. I want to say it was once a week. And then at school, he got speech therapy, but it was 15 or 20 minutes. They would pull him out of class with 3 or 4 other kids, and they would share that time to go over the speech therapy. So it was a significant reduction in the therapy he was receiving, but it was focused on education. So that's something to think about whenever you do have your IEP meetings, called ARD meetings in Texas, or if you're going to have something called Section 504.
And that's a great clarification. We did a whole webinar last year. Gosh, I think it was 2 hours, and we still had more we could talk about. We had a diagnostician, we had you there, and then we had Doug Levine, PT, who's familiar with DMD, talking. And Doug helped clarify. Yeah, those therapies, they are just to support them at school. I personally homeschool our son. So I always assumed, oh, then he can, the kids can just get PT at school. They don't need to go to their own therapist at clinic. And no, that's not quite right. But there's a whole lot of information from a recorded webinar. I plopped that here in the chat, and I'm putting a bunch of things in the Facebook chat comment section. So if anybody wants to see those, y'all can go back to this afterwards. But yes, we had that YouTube playlist that we did from last year, and so that's in there for any more special ed 504 questions. If you have any questions, please ask them now. But like I said, it's kind of like an in-depth thing. Let me see. There's one chat here. Anybody ask a question? Oh, okay. We're still waiting on Jacob's. Okay, we will get to you, Jacob. I promise. I promise. Okay. And then let's see, step 8. Can you believe it? We're at the end. Wow. Guardianship and lesser restrictive alternatives.
Okay, so
You know.
remember how we talked about determination of intellectual disability to see if that child would qualify for additional programs where the IQ level has to be at a certain, like it's 70 or 75 in order for them to be eligible. So this topic also just relies on the child's capacity. And so what we have is in Texas, your biological parents are your natural guardians of their children up until the age of 18. And then a court will, or the law recognizes that 18-year-old as an adult with all the rights and responsibilities of an adult. So one of the things that we talk about when we have children with special needs is transitioning into adulthood. Are they going to continue to go to school past a certain age? There's different ramifications of things that happen just because they're turning 18. And being able to continue advocating for your child, making decisions about their medical needs, all of that's important. And so guardianship becomes an issue, possibly, because your child's an adult and you no longer have the right to access their medical records. You as their parent don't have rights to even get notifications of an ARD meeting at school that's coming up. You usually, if you have a good relationship with your ARD IEP team, then you'll still receive the standard notices of an upcoming meeting where they're discussing your child's goals and what they're allowed, what they're going to be having as far as addressing their challenges at school. But by law, the school doesn't have to notify you anymore because your child's an adult. So some people run into problems in the doctor's office where mom, let's say it's mom, takes son to the doctor's office. She won't have access to his medical records. She won't be going back into the exam room with the child anymore. And so for, especially with some of our kids with comorbidities, and if intellectual disability is a component, it is a comorbidity with DMD, you can't be your child's voice anymore. And so guardianship would be warranted. So what you would do, at least in Texas, if you're going to get guardianship over your adult disabled child, you can start that process as early as 6 months before their 18th birthday, because there's a lot of work that goes into this lawsuit. You are suing to take away your child's rights, and you keep making decisions for your child. But a court's not going to do that if your child has capacity. If your child is having muscular issues, not capacity issues, then they can, at age 18 or older, sign something called a durable power of attorney and appoint you, parents, as the agents. They can also, your child with maybe muscular challenges, but not cognitive challenges, can sign a medical power of attorney, a HIPAA release. HIPAA release will allow whoever you have listed to have access to your health information. So there's lesser restrictive alternatives is the key phrase that they use in Texas. Those are lesser restrictive alternatives that you can have your child execute so that you can still help them make decisions. There's also something called a SDMA. I think it's a supportive decision-making agreement, where your child promises that they will that they will discuss with whomever, their supporter, major decisions, if they have a major decision, if they're thinking about moving out of mom and dad's house, before they go and sign that lease, they're promising with that agreement that they're going to talk it over with mom and dad first to explore all the issues that are involved with this decision. So those are alternatives to guardianship. And then the guardianship, there's different types of guardianship. There's guardianship of the person, guardianship of the estate, partial guardianship, total guardianship. There's but you shouldn't be thinking about that, exploring that avenue if your child has capacity to understand contracts, to be able to read it, something as like a power of attorney, read it, understand it, and then sign it in front of a notary. Then you don't need guardianship.
And that's great. I'm glad you went through the different levels of restrictiveness, because as you were talking, I learned something every single time you open your mouth, Leona. It occurred to me that even if we've got adults with Duchenne who don't have an intellectual disability, living with Duchenne is exhausting. And so you might just be physically and emotionally just exhausted and tired to the point where you're like, medical decisions, geez, I don't, I can't manage that right now. So that's fantastic that there are those other alternatives. Can you?
No,
Hello?
there we go.
Okay. I had something amazing in Bruno. I'll let y'all know if that comes back to me. But okay, here's a great question. Guardianship, how much? How much does that kind of thing cost?
So we're finding out it's very expensive. You can have maybe legal services just for the attorney's fees can be around $3,000, but you have to pay for filing fees. You'll have to pay for service of process. And so what that includes is a sheriff coming out to your house to provide the service of process to your child. They have a constitutional right to be served with that lawsuit. And so you hire an attorney, they prepare an application for guardianship, you sign it in front of a notary, they file it with the court, along with something called a physician's certificate of medical examination, which is what is going to be the medical evidence that's provided in court to show that the guardianship is necessary. All that stuff is filed with the court, and then it's issued to a sheriff to take it to your house and give to your child. So you're paying for that too. Then you're also going to pay for, if you're in Texas, an attorney ad litem. That is the attorney that's assigned to your child, the proposed ward, to represent their rights, to represent them and protect their rights. So you will have $4,200 to $4,300 worth of fees and attorney's fees, filing fees, service of process fees, attorney ad litem fees. It's around that amount that we've been seeing.
That just sounds so brutal, serving your child with a disability.
No. I tell my parents to, look, you're going to have a constable has to come out there, or a sheriff has to come out there and put those papers in their hands. So I tell my parents to tell their kid that they're going to have a special delivery. And usually, the sheriff is going to read the documents that they're serving. They're going to understand what's going on. And a lot of them are amenable to making it taking a picture with your child when they're delivering it, making it fun, making it less scary. But yes, your child may also have to attend court. In Texas, we can, in our physician certificate of medical examination form, we have the doctor state whether or not it would be beneficial for that person to attend the hearing, and would they be able to contribute at all. And I really like it where we get the attorney ad litem to waive the appearance of the proposed ward, especially if it's going to cause them anxiety, being in a new place, being around people, having to wait your turn in this new environment. Now, we do have Zoom court currently, but that's not going to be forever, I don't think. And so when we do return to in-person hearings, it is something that you have to prepare your child for if they are going to have a guardianship hearing. And I offer to go to the courthouse with the parents, maybe a couple weeks beforehand, so that they can go at a time when it's less busy at the courthouse. Because just to get the child to acknowledge, they're going to have to go through a metal detector. They're going to have to go into a busy lobby on the first floor of the courthouse, and then ride up in the elevators, and then wait their turn for when the judge calls on them, and stay quiet and patient. And so all these things are factors that we have to consider when we're preparing for the hearing to have a guardianship.
Oh, wow. Okay. Thank you for that, Leona. Quick question. What did the SDMA stand for again?
Like supportive decision-making agreement.
Okay.
So I have something called a Gen Z packet for parents that have kids going off to college or transitioning into adulthood. I'll include the power of attorney and medical power of attorney. But with the supportive decision-making agreement, it's just the child putting down in writing that they promise to talk to mom and dad before they make a major decision. Sometimes we back it up with a effective immediately power of attorney that can override, the parent can override the child. But then you have to remember for these legal documents, if you have capacity to sign them, you also have capacity to revoke them. And so that presents a different issue if you have, what is it, oppositional defiance disorder. It's good. We have to figure out what works for your child.
Yeah, and you and I were talking a little bit yesterday about what's the law and what's reality, and having to navigate those two things, and kind of juggle all of that fun stuff too. So question, you brought up something, and guys, we are almost at the end, so if you're starting to drool, just grab a tissue, we're almost there. You mentioned Zoom. How much of this stuff can be done by Zoom right now?
Okay, well, I'll have to check, at least with
I know I threw you a curveball.
yeah. So when at the beginning of COVID, the governor allowed for non in-person. For most of these legal documents, you have to have them notarized, and then with the will, you have to have two witnesses in addition to the notary. And so one of the problems we had with COVID is that we didn't want to put people all in the same place and around each other. And one of the things that our governor had done was removed the requirement that the notary be in person when notarizing certain estate planning legal documents. And so we were able to go through Zoom and watch somebody sign their legal documents, and then those would be mailed to me, and then I would notarize them and then send them back, and it was an additional process. There is something called remote online notarization, where you have a special digital notary stamp, and then that can be something that you would utilize. Zoom, and you would handle that through Zoom or through the internet. So it just depends. What I do a lot, because I'm licensed in Texas, so I can prepare documents for anybody in Texas and North Dakota. But I can go back and forth from the very first initial consult being, either over the phone or via Zoom, and then just carry on our conversation those ways and via email. And then we can send over documents for review, go back and forth until everything is perfect. And then the client can either take the documents to a notary nearby or do the remote online notarization. And then we keep a digital copy in the office for safekeeping.
Leon, I don't know if you saw in the chat, but you have a you are starting to inspire mass immigration to Texas, and DJ's decided he's going to move here just
Nice.
for our laws and your expertise. I got some great PTs. I'll hook you up, DJ. We're good. Okay, great. And I appreciate that because, man, with the era of COVID, it's Zoom and the internet and all of this fantastic stuff is just so agreeable to the Duchenne lifestyle. A lot of our older guys with Duchenne and girls, it's really hard to leave the house.
Mm-hmm.
It's really hard. And so to be able to accomplish some of these things and do them by Zoom without having to leave the house and possibly risk your health, that's fantastic.
We've actually, when we started focusing on helping families with children with special needs, we made it a priority to try to accommodate. There's a lot of parents that have kids that are on the spectrum, and then they're very anxious whenever they're in a new place, and it's hard to find someone that can watch your child while you go to this important legal meeting with your attorney. And you don't want to have your child present for some reasons. You may not want them present because they're in a new place with new people and they don't do well with the change in their routine. But you can't hire the teenager from down the street to watch your child with special needs. So to help accommodate, we've been doing things this way using Zoom or just a telephone call or emails. We've been doing that for years before COVID. Oops, somehow you got muted.
Okay, you just missed me saying how amazing you are. Wonderful. Okay. Okay, so we're actually close to the wrap up point. I just want to hit two things and then we can open up for Q&A. Again, if anybody's got the drool written wiped off their face. If anybody wants to contact you, Leona, how would they do that?
Okay, well, we have the one Facebook group, Duchenne. It is Legal Information for DMD Families. We have our phone is number 713-462-1777. That'll be in the chat. My email is my first name, Leona, at phyllislaw.com. Phyllis is F as in Frank, I-L-I-S. I have phyllislaw.com as the website for my law firm. And then there's a hyperlink to get you to legal information concerning special needs. We have a YouTube channel that Lindy basically takes care of for me. And that one is one word. The name is Attorney Phyllis. So that one I like. We also, we're on Twitter and Instagram. Mm-hmm. Although I don't do enough on Instagram. I probably should. I'm too old for TikTok. I know somebody mentioned TikTok and I was like, oh, I don't know, maybe I'll think about it. But yeah, we actually, and we also have something online. So we put my calendar online. There's something called Calendly, And so it's calendly.com and then / Phyllis Law Firm. It'll all be on the chat. And then that way you can look at my calendar, what I have available, and you choose what time works for you. And then you can choose if you want to have a Zoom meeting or if it's going to be in person or over the phone. So whichever works for you. And then we offer free 30-minute initial consultation. So anything that we may have touched on, but not enough, and you have some additional questions from today's webinar, just contact us on calendly.com. And then we can go ahead and give you some more information and answer your questions one-on-one.
That's awesome. Thank you. Thank you, Leona. Oh gosh, we have just been chatting about this for years, and it's incredible what a void there is for legal assistance in our Duchenne community. So I'm so grateful for you and all you do. So I just want to give one more quick announcement before we open to Q&As. So we, in the past 1 hour and 45 minutes, we got us roughly up to about age 18. We will be having another webinar, like I said before, for the adults. We've got it Saturday, May 21st. Y'all will be the very first to be able to register. I will plop it in the link here. But you know, as I said, my son is only 11, but I'm meeting lots of adults with Duchenne, and man, it's just not fair, like about a billion levels. So some things that we're going to talk about is, well, we'll probably touch on that power of attorney thing again, because that's right at the cusp. We'll also be talking about insurance. When insurance changes over, we'll be talking about how you can work and earn an income and still keep your benefits. And we'll be talking about marriage. I mean, I know some of you guys want to get married, but can you get married and still have your health insurance? I mean, it's so tricky. It's just not fair, some of the decisions you guys have to make right now. But those are just some of the things we'll be tackling, and I'm really pumped and excited about it. Hopefully it'll help a lot of people. Hopefully y'all need help. Not, you know, y'all need help, but y'all need help. All right, guys. Any other questions? Feel free to plop in the chat. Thank you for bearing with all of my technical difficulties over here. For some reason, my computers don't like it when I do Zoom meetings. All right. Oh, here's a question for you, Leona. Is it ever too late to do any of this stuff? I mean, clearly it's too late sometimes, but I know for the guardianship that needs to be done only 6 months prior to 18 years old. But is some of this stuff kind of better late than never?
Oh, all of it, all of it. Everything we talked about, we should do. The guardianship you can file as early as 18, 6 months before the 18th birthday in Texas. I did run across a problem for a lady who had a child with Down syndrome, and her child was in her 40s, and she had been able to get by without needing any help with power of attorney, medical power of attorney, guardianship, because she had her daughter living at home with her. She kept her with the same doctors. So it didn't really become a necessity until her daughter wanted to explore her independence and move into a group home. And so they did that. And then soon after there was COVID. And so there were lockdowns. And then I don't know about a lot of you, but I know that with a lot of people during the lockdown, there was a lack of socialization, and a lot of people suffered from depression. And so there's these different factors that were starting to be apparent in this adult child. But mom had kind of lost the ability to call the shots with her daughter. And her daughter with the Downs did have, intellectual disability. And so even though that there was intellectual disability, it was very difficult for her to be able to switch insurance to get her in a new group home. It was very hard for her to have any medical professionals talk to her. She had to go through the nurses, because the doctors wouldn't even bother to return her calls, because there wasn't a HIPAA release in place. There wasn't medical power of attorney. There was no guardianship. And with the daughter's lack of capacity to understand the terms in these legal documents, power of attorney, medical power of attorney, guardianship was the best and only alternative for them. But it does take several months to go through this process. I do have some parents or some kids where their parents are suffering through Alzheimer's. And if you do have, it's hard to stop the bleeding because the people are vulnerable and they may be taken advantage of. And so there's a financial bleeding because they're losing money. People are making them, convincing them to, do a reverse mortgage and pull out all their equity and then spend it for them. And so you would think that a temporary guardianship would be warranted, but sometimes the courts don't think it's that big of an emergency, and they make you go through the longer process for permanent guardianship. And so you're sitting there in a holding pattern for about 6 months while everyone's doing their reports and their interviews, because you'll have a court investigator come out and do an interview. The attorney at Litem will do an interview. There's all these things that have to happen before you can have a hearing, and you're kind of stuck and you can't advocate successfully with you for your child. So that is one, she had to clarify to the court why guardianship was needed. So going back to your question, is it too late for guardianship? The daughter's 40 something. Well, a new set of circumstances happened where she wasn't able to just get by with just saying, hey, I'm mom, I make decisions. So it was warranted at that time. But yes, you should sign up for the waiver programs as long as your the disability conditions had manifested. Not that you had a diagnosis. Some people get afraid because they didn't go forward and get, let's say, treatment for maybe bipolar that may have started showing up at age 14 or 15. Well, then you can still sign them up for the waiver programs and show that this disability manifested before age 22. So that you can still do. Special needs trust, is it too late? No. You may not need a first party supplemental needs trust, but the third party, go ahead and get it done when you can, and then update your wills, update your designation of beneficiary forms.
Thank you. And let's wrap this up with Jacob's question. It'll be a teaser for the adult webinar. What happens to the money in the special needs trust, the third party, when the individual whose trust it's in the name of dies? Where's that money go?
Good question. Because you're planning that it's going to be filled with funds to help your child for the rest of their life and meet all of their financial needs. And so hopefully there's enough to meet their needs. And then if there's anything that's left over held in the trust after that person passes, in the actual trust agreement, whenever the grantor parents are meeting with the attorney, there is succession planning, there's succession language in the trust, which would say, I want anything in the event that the beneficiary passes, I want the assets to then flow to their heirs. And then you can say, if there are no heirs of my beneficiary, then I want it to go equally, half to mom's heirs and half to dad's heirs. That's how we typically handle it. But you can designate specific people or groups, charities, to be the recipients of the funds after the initial beneficiary has passed.
Oh, fantastic. Yes, we all need a Leona in our back pocket. We'll see what we can do about that. Thank you so much. Thank you, everybody. And for real, please use that Facebook group if you just have questions. It's just informative. It's just an informative. But you know, you just want to plop something in. Ooh, what should we do about this? And you don't want to do your free online 30 minutes. Then that's a great way to access her. And you know, I'm guaranteed that there are other parents with the same question. So feel free to start going through some of those old posts too. But thank you guys. Thank you for joining us. And we look forward to May. And I hope y'all have a great Saturday.
Bye. Thank you so much.
Bye, guys.